Namaste. In today's video, let's have a brief discussion on how Indian Succession Act discusses certain aspects of private international law. Now, sections 4 to 19 of Indian Succession Act talks about the concept of domicile, which is very, very important for private international law. So, section 4 to 19 discusses about how we determine the domicile of a deceased person. And it uses majority of the private international law principles that are used globally. Therefore, we are having a look at it. It is used, these set of sections are used to resolve conflict of laws when some foreign element is actually present in the case. The key points that we need to remember before getting into this topic is that a person cannot be without a domicile, that is, every person has a domicile compulsorily, and a person cannot have more than one domicile. For example, if a person has domicile both in India as well as in England, and some conflict of law is arising, should I be applying the Indian law or the English law? Again, the same question arises. Therefore, identification of domicile will be of no use. Therefore, there lies the rule. Every person must compulsorily have one domicile and only one domicile. Similarly, another point that we need to remember is even though the domicile is unitary in nature, the residence of a person can be multiple. He can have a residence in India, in USA, in UK, or even in thousand different countries at the very same time. Whenever we are talking about residence, we are talking about a physical presence. It should be no, not transitory in nature. For example, if someone is coming to India for a tourist visit, that doesn't count as a residence. It's transitory in nature. The fellow, when he's entering into India at that point in time itself, he's determined that he's going to walk away after he's finishing his tourism. When we are talking about domicile, it is always a combination of both the residence plus intention. So compulsorily, there should be a physical presence. Apart from that, that intention to reside permanently, indefinite intention that I am going to reside here forever. So it is not for a particular job, it is not for a particular duration of time, but a permanent intention that I am going to live here from now on. So with these key points in your mind, let's delve into what Indian Succession Act is talking about. Now, when you look at Indian Succession Act, domicile is actually discussed in Chapter 2 or Part 2 of Indian Succession Act. Specifically, the chapter is named as domicile. Sections 4 to 19 discusses about all the aspects of domicile, application of this part. Now we need to remember that we are talking about Succession Act, therefore the application part very clearly mentions that if it is a case of a Hindu, a Muslim, a Buddhist, Sikh or Jaina, this act will not apply. In essence, it is just saying that they have their specific Succession Act. For Hindu, there is Hindu Succession Act. For Buddhist, Sikh, Jaina also, it is Hindu Succession Act. For Muslims, it is actually the Sharia law that is applicable. But we are not using it as it is. We are just using this act to understand the basic principles of private international law with respect to that of domicile. So now let's look at section 5. Section 5 of the act actually talks about when to apply the domicile and in what aspect the concept of domicile is applicable. Now, as far as the immovable property of a deceased person is concerned, we are not bothered about the domicile. No matter what his domicile is, we are going to be regulated only by the law of the land where the property is situated. So, if the immovable property is situated in India, this act is saying it's the Indian law that should apply. We are not bothered about the deceased person's domicile. Similarly, if the property is situated in USA, then in such circumstances, USA's law will be applicable. If it is situated in London, then it is going to be the London law or UK's law. Now, domicile of the person has no role to play when we are talking about immovable property. But at the same time, when we are talking about movable property of the deceased person, it is supposed to be regulated by the law of the country in which the person had his domicile at the time of his death. So when he died, what was his domicile? That is what we are going to look at. So if his property is situated in France, then it is going to be the French law that is applied to determine how the property should devolve upon his legal heirs. Now, when we are talking about all these aspects, we also need to understand that this is a scenario which arises when the deceased has died intestate without writing a will. When he has written a will, then the situation is different. We have to look into different set of laws. Now we are just trying to understand when what law needs to be applied. So if it is an immovable property, we are going to apply the law of the land where the property is situated. If it is movable property, we are going to apply the law of the land where the deceased had its domicile at the time of his death. Section 6 is actually giving further clarity, saying that a person can have only one domicile for the purpose of succession to his movable property. So we are bothered about the domicile of a person only when we are talking about his movable property. And when we are talking about movable property, the person can be allocated only one domicile. In section number 7, we are talking about domicile of origin of a legitimate birth. If the child is a legitimate child, automatically the domicile will be the domicile of the father at the time the child was born. So when the child is being born, at that point in time, what is the domicile of the father? That becomes the domicile of origin of the child. If the child is born after the father dies, but is still a legitimate child, so when the mother was, let's say, 6 months or 7 months conceived, and the father died at that point in time, only after the father's death, the child is going to come out into the world. Then, at that point in time, what was the domicile of his deceased father at the time of his death? That will become the domicile of origin of the legitimate child. So what's the position if the child is illegitimate? Obviously, it will have the domicile of the mother. So domicile of origin of an illegitimate child very clearly is that of his birth mother. The time when the mother gave birth to the child, what was her domicile? That is going to be the domicile of the child. Section 9 talks about continuance of domicile of origin. As soon as the child is born, a domicile is allocated to the child. It's called as domicile of origin, and this domicile of origin will prevail until the child acquires a new domicile. So, until the child actively acquires a new domicile, the old domicile is going to continue for the child. So, a man can acquire new domicile by taking up his fixed habitation in a country that is not his domicile of origin. Which means that, let's suppose the child is a legitimate child. The father had domicile in India at the time when the child was born. Then the child is allocated domicile of origin as India. This is going to continue until the child attains the age of 18 and actively seeks some other domicile. Let's say the child at the age of 18 is moving to USA to, let's say, live its life in USA permanently. So it is getting a new domicile when it is moving to USA. So taking up a fixed habitation. So moving to USA constitutes taking up a fixed habitation. Now, these are various examples that are being discussed in the section itself. Have a look at it because these are all going to become your problem questions for your end semester exam. Very simple examples. If you have doubt regarding any of these examples, you can obviously raise it in the comment section and I will strive to give you the answer. Next, section 11. Section 11 talks about acquiring domicile in India. So, when can a person acquire domicile in India? By writing or giving a letter in declaration in his own hand that he wishes to become an Indian domicile. So, for that, while applying and giving his declaration, he should have at least resided in India 1 year prior to making such a declaration. Next is section 12, which is talking about foreign representatives. For example, a diplomat, if he is coming and living in India for, let's say, 5 years as a diplomat, as a part of his diplomatic mission, does he acquire domicile in India? Obviously, no. He is not going to acquire any domicile in India in such circumstances. Section 13 talks about continuance of the new domicile. A new domicile will continue until the person has replaced it with another domicile, until the former domicile has been resumed. So he goes back to, let's say, India, his domicile of origin. So let's take an example to understand this. A person from India, he's having domicile of origin in India and he's moving to USA with an intention to permanently reside in USA. Later on, he is shifting to, let's say, England. Now, when he goes to England, his domicile will change from that of USA to that of England. Now he has acquired a new domicile in England. Let's suppose he is again shifting back to USA or he is shifting back again to India. His domicile of UK will change only as soon as his former domicile, that is US's domicile, has revived. Or he can move to Australia, yet another new place, and acquire some other new domicile. So it is a scenario wherein his former domicile is resumed, or he has acquired some other new domicile. Until either of these scenarios arise, the new domicile that he has in his hand, that's London in our example, it will continue. Section 14 talks about domicile of a minor. So we need to remember that as far as a minor is concerned, he follows the domicile of the parent. So when the child is born, he is assigned a domicile of origin depending upon the father's domicile. So the father is there in India, having Indian domicile when the child is born. Then the child has domicile of origin as India. After the child is born, let's suppose the father moves to England. Then the child will have his domicile of origin as India and his current domicile as England because the father has shifted to India. The child can acquire some other new domicile only when he is attaining the age of 18. There are certain exceptions that also we need to see. So a minor can obtain a domicile different from that of his father in certain circumstances, such as when the child is married. When the minor child gets married, he or she can acquire a new domicile. Similarly, if the minor is employed in government service, for ease of, let's say, paying his income tax, he can acquire a new domicile. Or if he has obtained some other, he has set up some other business, a distinct business from that of his father, and for the purpose of income tax, he requires a new domicile. Only with the consent of the parent, he can acquire a new domicile. So this is as far as minor's domicile. It is always going to follow that of his father. Next, for a woman who is married. So if a woman gets married, at once she obtains the domicile of her husband, even if she is not set foot in that country ever. So let us suppose a British domiciled man is coming to India and marrying an Indian bride. She is having domicile of origin as India, and until her marriage, her domicile was India. But as soon as she is getting married to her husband, at that moment, at that very same moment, she acquires the domicile of England, even though she has not gone to England in her entire life until that point. As far as the domicile of a woman during her marriage. So she acquires, in our example, she acquires the domicile of her husband, even though she has not stepped foot in India. And as long as she is remaining married to her husband, she will continually follow the domicile of her husband. The domicile of her husband actually becomes the domicile of the wife. It is actually called as unity of domicile. As between a husband and wife, there is always a unity of domicile. The wife always follows the domicile of the husband, unless otherwise there is a case of judicial separation, or if the husband is undergoing a sentence of transportation. In these circumstances, the domicile of the woman will not change. When can a minor acquire a new domicile? We saw three exceptions. Apart from that, a minor cannot obtain a new domicile during his minority. As far as a lunatic is concerned, the lunatic cannot acquire a new domicile in any way except by following the domicile of another person. Who is this another person? The another person refers to his parents in case he is a minor, and if he is above age of 18, it refers to the guardian. If the guardian thinks that it is best for the domicile to be changed, then the minor can change his domicile. Sorry, the lunatic can change his domicile. Section 19 talks about a scenario relating to succession to movable property in absence of proof of domicile elsewhere. So if a deceased person dies leaving his property behind in India and nobody is able to prove that he is having domicile elsewhere, the court will simply presume that he is having domicile in India, and the court will apply Indian Succession Act for the deceased, both for his immovable property as well as his movable property. When I am talking about immovable property, I am talking about immovable property that is situated in India. So now that we have had a discussion on all the sections of chapter 2, that is section 4 to 19, let's have a recap of the same to ensure you have understood it clearly. Chapter 2 of Indian Succession Act lays down the following conditions. First and foremost, for the deceased, if he is having property in India, then immovable property is to be dispersed as per the Indian law. When we are talking about movable property, even if the property is situated in India or elsewhere, we look into the domicile of the deceased and we apply the law of that particular nation. For each person, only one domicile is assigned. Every person has a domicile of origin, and for a legitimate child, father's domicile will apply for the child as soon as it is born, even if the child is posthumous. If the child is illegitimate, obviously the mother's domicile will be applied. Domicile of origin will continue for a person until he is acquiring a new domicile. A person can acquire a new domicile by taking up fixed habitation in some other country. Now, when we are talking about acquiring a domicile in India, the person must reside in India for at least 1 year and then give a letter of intent or a declaration as it is put in the Act to the appropriate authority appointed by the state government. Now, who is this appropriate authority? Generally, it is the Tahsildar's office or the collector's office. If a foreign diplomat is posted in India, he does not acquire domicile because he is here for a diplomatic mission. His intention is not to permanently reside in India, therefore, no new domicile. Newly acquired domicile obviously will continue for a person until he either reverts back to his domicile of origin or acquires some other domicile. And much more importantly, Section 19 says that if a person dies, leaving behind his movable properties, and there is no proof of domicile to be found elsewhere, the court simply believes that or presume that he is having the Indian domicile and the Indian law, specifically the Indian Succession Act, will be applied for the person. Now, we also saw certain special cases, the case of a minor. For a minor, it is pretty clear that he cannot change the domicile to be different from that of his parent unless he is either married or he is holding office or office of service in the government, or he is having some business and the parents have consented for him to change his domicile for, let's say, the purpose of taxation. Then, apart from these three conditions, no other methodology for a minor to acquire a domicile on his own. He will be simply following his parents' domicile. If legitimate, the father's domicile; if illegitimate, the mother's domicile. The next special case scenario that we had seen was with respect to that of a married woman. For a married woman, as soon as the marriage is over, she acquires a domicile of her husband, and that domicile continues during the subsistence of the marriage unless she is judicially separated or she has obtained divorce or it's a case of transportation sentence for her husband. Now, as far as a lunatic is concerned, he or she can acquire a new domicile only with the no permission of his guardian and following the domicile of his guardian, a parent in case of a minor or a legal guardian in case of a major. Now, there are two case laws that I would like to discuss to help you understand this concept in a better manner. In Louis versus Union of India case, it was observed by the court that for acquiring a domicile of choice, so after domicile of origin, whatever domicile the person is acquiring, different domicile a person is acquiring, it is called as domicile of choice. So for acquiring a domicile of choice, two things must be proven. First and foremost, his status of mind, animus manendi, that he wishes to remain in some country for an unlimited period of time. Apart from that, it is also necessary to prove he is having a residence. So domicile is always a combination of residence plus intention, as we have seen earlier. So residence alone is not enough. Animus manendi, or an intention to remain in that country for an unlimited period of time, should be shown. Only then a domicile can be attained. In this case, the court observed the burden to prove that the petitioner's intention to stay permanently in India lies upon the petitioners themselves. So they have to showcase both proof of residence as well as an intention to remain unlimitedly. Mandal versus Mandal case will help you understand this in a better manner. Now, two Austrians who were actually domiciled in Austria, and these two people were actually married in Vienna prior to that of attack on Vienna by the Nazi Germany. So the Nazi Germany won the war and they took hold of Vienna, and these two Austrian citizens, they escaped to India and settled down in India. Later on, the war was over and no, Austria, or the combined world war ensured that the Germany was defeated. Then these refugees who had come to India, they did not return back to Austria. They continued to stay in India, which showcased that they had obtained a domicile in India, and until their death, they had stayed in India, proving that they had the intention to stay in India for an unlimited period of time. So, to prove that a person is having a domicile in India or any part of the world for that matter, it should be proven that there is residence as well as animus manendi and intention to stay in that country permanently. So with this, we are coming to an end for this particular video. If you have any doubts, please raise it in the comments so that I can answer it. And if you found this video informative, kindly like, share, and of course, subscribe to my channel for more such informative videos. Thank you.